Good morning, ladies and gentlemen. I'm Phil Porter. I'm an attorney with the Department of Consumer Affairs, and I'm going to be hosting the webinar this morning. We're going to basically hit some issues in collection, but we're also going to do some preliminary things first, and so let's get those out of the way. First of all, as a disclaimer, I'll try not to read it quite as fast as they do on the radio commercials. This presentation is not meant to serve as a substitute for reading the various laws discussed, seeking legal counsel, or otherwise requesting department guidance and/or interpretations on the law it administers and enforces. The presentation merely serves as an introduction and overview. All right, our roadmap. What are we going to cover today? Well, first we're going to tell you a little bit about the department itself. And then main thing is we're going to cover state and federal collection laws and how they affect you and what you can do to effectuate your rights and be careful about situations regarding collection laws. We're going to cover some recent changes in the Federal Act. That's the Federal Fair Debt Collection Practices Act. And we're going to touch on some other collection issues such as repossessions and statute of limitation issues. But first of all, how can the South Carolina Department of Consumer Affairs help you? Now, the department was established in 1974, I should say, by legislation that was passed in 1974, which became effective January 1st, 1975. Now, if you've noticed, that means that we are just past our 50th birthday as an agency of the state of South Carolina. The South Carolina Department of Consumer Affairs is the administrator and enforcer of South Carolina Consumer Protection Code, as well as other regulatory statutes impacting consumers. In this capacity, the department helps to formulate and modify consumer laws, policies, and regulations, and regulates the consumer marketplace and resolves complaints. We have mediation authority for complaints in South Carolina that does not necessarily impact consumer credit, but does impact consumer sales of services and goods. In addition, we are the consumer advocate. Our administrator is also the consumer advocate, which means that we represent consumers in general in regulatory cases before the PSC, in certain cases in the insurance department. What can you do with the department? Well, you can file a complaint. Some people have never thought about filing a complaint, but some people are dissatisfied sometimes with the goods or services they get or the deals they get in the marketplace. And in some cases, those deals are not in compliance with the contract, perhaps not in compliance with law. You can file a complaint with us. In some cases, we do have regulatory authority and can enforce laws involved in those complaints. In other complaints, we just have mediation authority, which means we can't force a settlement of one sort or another against the parties, but we'll show you how that's still useful to you in a moment. You can report a scam. Now, I don't know how many of you have been victims of scams, or whether you know you've been victims of scams, but scams can come in a lot of forms, by telephone, by email, by text, and so forth. And there are all sorts of strange things that they sound too good to be true, and that's because they are. They claim that you are a winner of some lottery that you never entered, or that some government of a foreign country wants to get you in on a deal to be able to give you millions of dollars to put things through your bank account. Usually, if they sound too good to be true, in fact, always if they sound too good to be true, they are. We can help you avoid these things. You can report ID theft. South Carolina Department of Consumer Affairs has an entire section that deals strictly with ID theft. And some people have had ID theft that they haven't been hurt by yet, but ID theft is when some person, a criminal, a wrongdoer, finds some portion of your social security number, some address of yours, your phone number, your account numbers for utilities, your account numbers for credit cards, and they can piece together information where they can make new creditors or new service providers think that they are you. And then they'll get this credit in your name, and it'll appear that you owe money when you don't. And sometimes it's difficult to resolve. Sometimes you need the assistance of law enforcement, and sometimes you need assistance of the department to help you do the things you need to do to repair your credit once someone dings it with ID theft. You can get background on a business. As I've said, we administer a complaint mediation system, but this can also help you before you have to get a complaint. For example, let's say that XYZ Corporation is selling vacuum cleaners, and you want to know if they do a good job, or you want to know if they comply with their contracts. Well, you can look up XYZ Corporation with the Department of Consumer Affairs. You can contact us by our website and find out whether that corporation has some sort of traffic in complaints. Now, you have to be careful what these things might tell you. For example, XYZ Corporation may be a small town company that sells vacuum cleaners, and they may have 5 complaints, of which 1 is unsatisfied and 2 are satisfied, and 3 or 2 or more are closed in some other way, undetermined or lack of information, something like that. Now, that may tell you to be warned about going to that business, but let's say XYZ Corporation is a big international business that sells billions of dollars worth of vacuum cleaners. The fact that they might have 5 complaints may tell you a different story. And also, the status of the complaints will tell you a different story. If there are a lot of unsatisfied complaints, then that might tell you you might be careful about doing business with that business. It doesn't always mean that the business is a bad business if it has complaints, and we tell businesses you need to monitor your complaints because they tell you they're a good barometer to tell you what sort of a picture you are painting for the people that are your customers. Free presentations, we do that, like this one. But it's not just webinar presentations like this one. We do free presentations throughout the state. It doesn't matter whether it's in Horry County or in Beaufort County or in Oconee County. If, let's say, you have a civic organization, Civitans or Sertoma or something like that, or your church or other community organizations are interested in some topic that has to do with consumer goods or services, we will have someone come to your location if you arrange it ahead of time and give a presentation on it, and they will have whatever documentation we have or free brochures that deal with those types of issues, and we're happy to do it. And answers to your questions. Now, one of the advantages of being 50 years old and being a consumer organization that gets questions coming in from consumers about all sorts of consumer transactions is we've probably seen or heard most of the questions that are out there. So even if we can't directly assist you with the question or problem that you have, we usually have heard the question before, and we know who to send it to, whether it be the federal government, a government of another state, a mediation organization of an industry in this state or another state or something like that. Now, this is our website. Now, I've mentioned several of the topical areas, which you can see here. You can even click on it in 2 different ways. But if you'll go to the one with the white background, right here, you of course can file a complaint with us. If you are in an industry that is regulated by the department, you can get a license. If you want to get a background on a business, as I have mentioned, you can do that by getting complaint reports. If you're a victim of identity theft, that as well. If you want to report a scam so other people will not be victimized by it, that we can do that too. And please make note of our contact information here at the bottom, www.consumer.sc.gov. And our toll-free line used to be just in the state, but now it's nationwide, 800-922-1594, if you want to get in touch with us. So, on to debt collection. Well, what is debt collection? The process of pursuing payment of debts owed by individuals. Now, let's do a little background here. If you owe debts, quite often you're going to get some people interested in getting you to pay your debts by various ways of persuasion. Some of them can be convincing. Sometimes they can be a little bit obnoxious in the view of the people that owe the debts. Sometimes they're willing to do some sort of settlement of less than full number of dollars owed and so forth. But the problem with debt is if you owe a debt, it's not necessarily going to be your best interest to ignore it. Just because people are pursuing you and wanting to call you on the phone or write letters to you, if you ignore it, it's probably not going to go away. Debt collection is carried out by organizations that specialize in collecting debts. They may be the creditors themselves. They may be collection agencies specially set up in business to collect debts. They also may be agents of the creditors. For example, law firms that specialize in collecting debts, or just businesses that arrange to collect debts for a fee or percentage of the debt collected. Who is a debt collector? Well, of course, the original creditors are debt collectors. Now, the asterisk is there because debt collectors are in a little bit different situation than some of the collectors that we're going to talk about. That is because under the Fair Debt Collection Practices Act and under the Consumer Protection Code, they are not among the debt collectors that you can simply say, I'm tired of hearing from you, don't call me anymore. Okay? That does not apply to creditors under either the South Carolina law or the federal act. Of course, there are third-party debt collectors that we've talked about, attorneys that we've mentioned briefly, and debt buyers are a fairly new situation in South Carolina and throughout the country. Debt buyers, something you need to understand is in some cases, particularly with creditors that have some connection to federal banks or federal regulations, may be required by those regulations to so-called write down or write off the debt if someone has been in debt for a fair amount of time and has not made payments on the debt. Now, this does not necessarily mean that the debt goes away. It simply means for the investors or the creditors of that creditor that is an asset that may be in question and may not be paid in full or maybe not be paid at all. Now, what debt buyers do is they say, well, we're pretty good at collecting debts, so we're going to buy the outstanding debt from, say, a credit card company. We'll buy it on cents from the dollar, and we will attempt to get collection from the consumers involved that owe the debt. And sometimes they're successful and sometimes they're not, but they are in business to do that and sometimes are successful. How are debts collected? Well, people are usually familiar with the direct contact, the phone calls, the letters, and the emails. Now, credit reporting is sort of what you'd call a soft debt collection. People are mostly familiar with credit reporting agencies, but they probably need to get more familiar. Credit reporting agencies are what I like to describe as sort of reporters of your footprints in the sand. If you get credit and if you pay it well, they will report that. If you pay it back timely, they will report that on credit reports that prospective creditors who are interested in giving you credit will note. However, if you do a bad job or do not pay your debt at all, that also will be reported by credit reporting companies, and that will also be reported by the credit reporting companies to any of the creditors that are interested in giving you credit and you are interested in getting credit from. Debt settlement. As I mentioned before, in many cases, the creditor is going to understand this debtor probably cannot pay the full payment, but the creditor may be willing to settle for 80 cents on the dollar or 70 cents on the dollar, whatever it may be. Care needs to be taken here. If there is a debt settlement, unless the agreement states otherwise, the fact that you haven't paid 20% or 30% of the debt doesn't mean that you are forgiven the debt. It just doesn't mean, it means that they're not going to pursue it any further. And that is also a fact that may end up on credit reports. So beware. Litigation. Now, nobody wants to be in litigation as a debtor, but those are things that ultimately transpire when people do not pay their debts. Litigation can be one of two things. It can be on the debt itself and only the debt, or it can be in the form of what the courts call claim and delivery, where in addition to the debt, there is, for example, a motor vehicle that is security for the debt that the creditor is attempting to repossess at the end of the process, repossess that, and then sell it in order to settle as much of the debt as they can. And there are other methods that we'll go over. Repossession is one of them. Now, as we'll note, repossession can be either voluntary or involuntary, but make a note. You can't just say, you can't come on my property to repossess my vehicle. That is specifically allowed for creditors that set up their contracts correctly under the Uniform Commercial Code, and those things are pretty uniform with the creditors that give credit in the case of motor vehicles and similar products. Garnishment. Let me give you a little bit of warning on garnishment. The general rule in South Carolina is there is no garnishment. We'll go over the exceptions in a little bit. But if someone says they're going to garnish your wages, they're probably saying they can do something they cannot do, unless it's in these certain situations, such as you owe the debt from another state before you moved into South Carolina, that they're trying to garnish the debt that existed in the other state. Debt collectors must follow a number of rules, which we're going to go over. There are state debt collection laws. There's the Fair Debt Collection Practices Act, which we've touched on. We haven't gone into detail as we shall. There's the Telephone Consumer Protection Act. I don't want you to get too misled by that act. That act is primarily designed to allow people to deal with unwanted solicitations. It impacts somewhat the idea if by chance you are being approached by someone that you're not even sure it is a debt you even owe, that may be sort of a solicitation, or it may be some sort of come on for a ripoff. But primarily, you might want to take a look at that act, because it is something you can do to protect yourself and even be able to sue people that violate it if they contact you after you put them on a no-call list and so forth. And there's the Fair Credit Reporting Act. We mentioned briefly the credit reporting agencies, and of course those agencies are Experian, TransUnion, and Equidata. As an aside, everyone, whether they have bad credit or good, whether they have a lot of credit or a little, should probably check their credit reporting with those agencies. You are allowed to do it every week with each agency, which is a lot more than you really need to do. But you need to do it about monthly or not less than monthly. So you can, one, see if there's bad credit that is improving, or what you can do to improve your credit, or to find out whether there is false credit on your accounts that doesn't even involve you. And that's the way to figure it out before it gets too entrenched. But of course, as we've said, the credit reporting agencies, they do a pretty good job. They sometimes make mistakes, but they're pretty much just reporting facts. And if they're reporting things that are not facts, they need to get notified so they can correct it. There's a South Carolina law as part of the Consumer Protection Code that deals with unconscionable debt collection practices. It applies to all creditors, including the original creditor, the third-party debt collectors and agents and so forth, as well as repossession agents. It provides consumer protection against unfair methods of debt collection. And it used to be entirely defensive. It was a defense to collection agency, or not just agencies, but collection actions which were unfair or deceptive or abusive. But that law was changed, I think, back in the 90s to make it something that consumers could bring affirmative actions if their rights were violated by abusive debt collection. There's the Fair Debt Collection Practices Act. We've mentioned it briefly. It is a federal act. It is administered in part by the two federal agencies that you see at the bottom of the screen, Consumer Financial Protection Bureau and the Federal Trade Commission. It provides protection against unfair methods of debt collection. It's broader than South Carolina law, but it applies only to debt collectors hired by the creditor, creditors who use different business names when collecting debts owed to them. Now, this is a little bit confusing. The general rule is it doesn't apply to the creditor, but now suppose that a creditor says, it'll be more convincing if I make my communication with this consumer look like it's somebody scarier than a creditor. For example, I'll make it look like on the envelope that this is a mailing from a federal government agency that they're in trouble with, or that we are actually a collection agency, a third-party collection agency that might treat them rougher or whatever else. So if they pretend or make it appear that they are someone else, they may bring themselves back into the scope of the law. So how about communications with debtors? They include phone calls, mail, email, and texts. Generally, contact is allowed between 8 a.m. and 9 p.m. The supposition, obviously, is that people will either be asleep in those other hours, or they'll be getting up and showering and getting breakfast, getting ready to go to work. And after 9 p.m., they may be wanting to retire again. The creditor or collector cannot repetitively call in a 24-hour period. Under the Federal Act, you cannot contact at times known to be inconvenient. Now, what does that mean? Because it's said between 8 a.m. and 9 p.m. Well, suppose that the consumer who owes the debt works third shift at a plant and gets off work at 7 in the morning. Well, that person quite often is going to need to go home and go to bed in the next couple of hours. So it could be that if someone calls them at 10:30 in the morning or at 11 in the morning, that is just as inconvenient as calling at midnight or 1 a.m. for someone else if the creditor or the debt collector knows that. The collector cannot call someone known to be represented by an attorney. Now, this is one of the new things, is the so-called 7-7 rule. Debt collector cannot call a consumer more than 7 times within 7 days or within a period of 7 consecutive days after having a telephone discussion with the debtor in connection with the debt. But it applies to each debt. That means if you got 3 or 4 accounts, the debt collector can call you the 7 times with regard to each debt. And maybe if you have that situation, you better consider avoiding quite so many debts. Exclusions are calls where the debtor has given prior consent, so the debtor probably should make sure the debtor doesn't sign some document that somewhere in the terminology says they're giving consent to be called. Calls that don't connect with the dialed number. If you don't pick up the phone, it doesn't count as one of the contacts. Okay, and if the number doesn't get through or the call doesn't get through, that doesn't count. Also excludes calls to specific professionals such as the debtor's attorney. In other words, the whole point is if the debtor has an attorney, you want to encourage and not discourage communications with the attorney to be able to settle the account in some way that is overseen by the court or with proper advice. Communications with third parties. This has always been a rub in connections. Generally, debt collectors cannot communicate with third parties regarding a debt. There's an exception. They can communicate with third parties for location purposes. They can ask for home addresses, they can ask for work addresses, they can ask for phone numbers. They cannot indicate that the consumer owes a debt to that third party. Debt collectors may not harass, oppress, or abuse you or third parties they contact. They may not use threats of violence or harm, use obscene or profane language, or repeatedly use the telephone to annoy someone, be they a third party or the debtor themselves. They cannot publish a list of consumers who refuse to pay their debts. Now, when I was in college, there were certain merchants that if they accepted checks and people bounced their checks, they would put a big poster that had all the checks and the signatures of the people who would bounce checks. That's not really credit as such, but that probably would not work today either. Cannot make false statements. The debt collectors may not falsely imply or state that they are attorneys or government representatives or credit bureau employees. They cannot misrepresent the amount of the consumer's debt. They cannot indicate that the papers being sent to the consumer are legal forms when they are not. But on the other hand, they cannot indicate the papers being sent to the consumer are not legal forms when in fact they are. Also, they may not falsely state or imply that you have committed a crime. Now let's go into this a little bit. Sometimes this tactic is used by some debt collectors, the disreputable ones. However, with certain very limited exceptions, simply owing a debt is never a crime. There are no debtors' prisons in South Carolina or the United States. Now, what that doesn't mean is that if you commit fraud and you end up owing money because of some action of yours of committing fraud or some other crime, that you cannot be prosecuted. But simply owing the debt is not part of that. They cannot state that you will be arrested if you do not pay your debt. And if they do say that, they are violating the law. They cannot threaten to seize, garnish, attach, or sell property or wages or initiate litigation unless they have the legal right to do so and they intend to do so. In other words, they can't say they're going to do those things if they don't intend to do it. And bear in mind, the word garnish there is pretty much a no-no to begin with. It's not going to happen except in the limited instances that we're about to go into. They cannot collect any amount greater than the debt unless state law permits such a charge specifically. They cannot deposit a post-dated check that they have asked you to give them prematurely. Also, if they are soliciting post-dated checks, that's kind of a bad sign anyway. They cannot contact a debtor by postcard. Why? Well, if it's a postcard, you can see the front and back of the postcard. And if they're contacting a debtor for that reason, they're almost certainly putting something about the account on the postcard. And by its very nature, it can be seen by the postman, by anybody in the family, or anybody who rifles through your mail will know that you owe a debt that people are trying to get collected. How about contacts at work? Well, a debtor or the employer of the debtor can send a request to cease contact, but it must be in writing. And anytime you send in writing, particularly when it has to do with debt collection, you probably need to send it in writing, return receipt requested, certified mail. The creditor must then stop contact. There are exceptions to this. They can verify employment or limited contact, particularly for purposes of saying, okay, we're going to stop calling you now, but people that owe debts probably need to beware. If you get to this point and you're telling people to stop contacting you either at work or at home, then the alternative may be the next step, which is litigation. So it may not be any more pleasant than hearing people talk to you on the phone. All right, stopping contact at home. It is important, and this is only according to the federal law. It only applies to third-party debt collectors, not original creditors. But if you send a written request for the debt collector to cease a contact, they will have to do that. The debtor can consent to limited contact, in other words, for mail only or email only. The debt collector then cannot contact the consumer except to inform the consumer that specific action will be taken. In other words, well, if we can't call you, we're going to sue you now. So this is the last time you'll hear from us other than that. Debt Collection Practices Act validation and dispute process. This is another new factor. They need to give notice in the first communication or within 5 days, and it must contain the amount of the debt, the name of the current creditor, the original creditor, disclosures, which the debtor has 30 days to dispute the debt or it's assumed valid. Now, let's take a minute with this too. If they give you a notice that says dispute the debt within 30 days or it's assumed valid, and you believe that it is not invalid, you need to respond. Because if you don't, that may be used against you. We gave the person a chance to dispute the debt. We told them to respond within 30 days. We didn't hear from them. That should be considered an assumption that the debt is correct. It has to contain an explanation of the validation process. It must say that the sender is a debt collector and attempting to collect a debt. And, of course, as already discussed, the debtor may dispute the debt in writing. Collection attempts must stop while the creditor seeks verification, and as with all these writings, it is a wise thing to send them certified mail. All right. Additional changes. The validation must contain one of the following itemized dates. Either the last statement date, if applicable, the charge-off date, if applicable, the last payment date, the transaction date, or the judgment date. This is to allow you, if you are a debtor and there is a question in your mind as to whether it's even your debt, that you can check your records and easily determine whether it's a mistake or whether it's something that you maybe forgot about, or you know that you actually owe the debt. The itemization of current amount of the debt reflecting interest, fees, and credits. And you, as a consumer, need to confirm whether or not the debt is yours. Get the collector's information, Do not give additional personal information. In other words, they may say, we're just trying to confirm the last 4 digits of your Social Security. Can you give that to us? And you may think, oh, these people say I owe them a debt, I better cooperate. No. If you really owe them a debt, they probably know all that information, so don't give anything additional. Do not discuss the debt without the validation notice. Just say, I understand you have to have a validation notice. I haven't received it. Please forward it. Then dispute the debt in writing and send it, as we've said, by certified mail. Other collection laws applying in South Carolina. Let's talk about defaults. There are 2 types of defaults in consumer credit transactions. The first is putting the collateral at risk, and usually this is going to be some sort of security interest, primarily in finance vehicles or some sort of personal property. Why? What is putting the collateral at risk? It is failing to maintain insurance on finance vehicles. Now, that may not be the only thing that puts the collateral at risk. It's conceivable a consumer could say, well, I'm going to hide this car and you'll never get it, and I'm going to file bankruptcy, this, that, and the other. Thing to remember, though, is whatever the circumstances, it's always the creditor's burden to show that the collateral is at risk based on whatever the consumer may have done. The essence of this, though, is if the collateral is at risk, the creditor can accelerate the obligation, which means we're going to say that the whole obligation is due now, not just the monthly payment. Or they can take action to repossess or sue the consumer for the obligation. Then there is failure to make payments. If it's any failure to make payment that doesn't put the collateral at risk, then the consumer may be subject to a suit for repossession of collateral, but it only occurs if it's been 10 days or more past the due date of the scheduled installment. Okay? Once the payment is in default and before the repossession is initiated, the creditor must send the consumer a right to cure letter sent after 10 days in default, generally speaking the 12th day. Gives the consumer 20 days to pay or cure the default. Now let me back up. There may be some creditors that are only subject to federal law and so forth, are not necessarily subject to the Consumer Protection Code. However, as a general rule, they will have by contract a right to cure that will be something like this if they are legitimate creditors. Now, if the consumer pays within 20 days or cures the default within 20 days, the effect will be as if the default never occurred if the payment is made. How many right to cure letters must you be sent? Well, it depends. If it's closed in other words, you're financing your automobile, you only get one shot, only one bite at the apple. If, on the other hand, it's an open-end account like a credit card, you get the opportunity to get a cure notice every 12 months because it's an ongoing and may even be perpetual transaction where people get, get credit from time to time. Where does the consumer right to cure need to be sent? Well, here is a trap that people need to think about that they can get in. It's the consumer's last address on file. Let's say you and your spouse or you and a friend get credit in both of your names, and you have a separation or a divorce, or you simply move from the address that you had whenever you entered into the transaction. The creditor has the right to communicate with you, including the consumer's right to cure, at the address that they have on file. And until you correct that address in their files, they may send you whatever notice is there, including the consumer's right to cure. And if you fail to cure within that time, it's on you. You may not have the right to cure at the end of the day. So be careful about that when you move to another address. It's important that consumers update creditors with any address changes. Okay, how many kinds of repossessions are there? Well, there are voluntary repossessions. The consumer may say, well, gosh, my hours have been cut back. I just cannot afford this. I'll have to take the bus for a while, so forth. I might as well just give the creditor the keys to the car and have a voluntary repossession. That can happen. There's nothing that prevents it in the law. In most cases, the creditor is going to ask for some sort of written statement acknowledging that it's consensual. And notice of right to cure does not have to be given if there's a voluntary surrender. However, the repossession is not deemed voluntary if the creditor uses force or some sort of deception in order to take possession of the collateral. There is self-help repossession. Now, a lot of people think that just because your car is parked somewhere in your yard or in your driveway, a lender or a creditor is not susceptible to being able to repossess that vehicle. Creditor may go pick up the collateral or send a repossession agent to pick it up. Now, there are some restrictions, but in most cases, once again, there's that UCC, the Uniform Commercial Code, that has a provision that says that the creditor can write their contract in a way that allows them to repossess collateral that they have a secured interest in. So they don't have to have the consumer's permission for a self-help repossession. However, it cannot take place in any action that may lead to a breach of the peace. Well, what is the breach of the peace? If the consumer objects, the creditor should leave. Certainly any situation where there's a big argument, certainly in any situation where either of the parties brandishes a weapon or puts up a fuss where there's a chance that people may get hurt, the creditor or the creditor's agent should leave, come back, go to a magistrate and get an order, and perhaps bring law enforcement to the situation to avoid having bloodshed or violence that results from a repossession. Any threat or use of force is a breach of the peace. So if by chance the creditor or the agent of the creditor says, I'm going to bash you in the head if you try to resist, that also is a breach of peace. As a general rule, the creditor may not enter a person's home without permission. Now, what is a person's home? Generally speaking, that is going to be regarded as anything that the roof of a dwelling place covers. In some cases, the roof of the dwelling place can cover a built-in garage. In other cases, a garage may be a separate structure from the dwelling place. So that usually is considered the dividing line. Then there's also claim and delivery action in courts of law, usually magistrates' actions. Begins with a summons and complaint, but also has a demand for immediate possession of the collateral. The debtor will have a right to respond and must request it within 5 days after being served. Consumer has full 30 days to file an answer. Now, I'm not here to tell you that if you owe money that you're going to be able to get out of it just by filing an answer. But if you have something to tell the court, you need to tell the court that, and you need to do it in writing in some form of an answer. Because I can tell you the percentages of you being able to save your vehicle without answering it is going to be 99.9% of the time ineffective. You need to respond to the court. You won't always win, but sometimes the court will try to see what sort of other result could transpire from it if the court judge gets a chance to talk to both parties, as opposed to just okaying the repossession and so forth. Always ask for your day in court if you expect to have one. If the judge rules the creditor has a right to immediate possession, the court order is entered and law enforcement may even take possession of the property, even if it's inside the home, once the court has ruled. Consumer's right to redeem. Here's another thing that's covered by the Uniform Commercial Code. If it's ultimately repossessed, the creditor must inform the consumer of its intent to sell the property. They will have to inform the consumer what kind of sale they're going to have, whether it's a public or a private sale, and when to show up if they want to have someone, a relative bid or even pay off the obligation. Consumer has a reasonable amount of time to pay what's owed to purchase the collateral outright. However, bear in mind, the creditor may require full payment of the amount due, not just late payments, but also storage, repossession fees, and so forth. And in many of these cases, it's not going to just be a default for 1 month. It's going to be a default for 3 or 4 or more months, where the consumer is not going to be allowed to pay what's due, but the debt will then be so-called accelerated, which means in order to redeem the collateral, you have to pay the entire amount. If the money is still owed after the sale of the item, the creditor may pursue the rest through a court action on debt. The security, once it's sold, it can no longer be repossessed, but that doesn't mean the consumer doesn't owe the debt. Sometimes consumers think that, well, once they got my car, that's all they can get. That's not necessarily true. Garnishment. All right, we've covered this pretty well, but here, the exceptions. If you owe money to the government, sometimes the government can take action to garnish your wages or hit your tax refunds. If the money is owed for child support or alimony, the garnishment order was issued and enforced by another state where the consumer was a resident at the time the debt was incurred. And as I mentioned briefly, income tax refund garnishment was allowed in certain situations. All right, people get all wrapped up in statute of limitations. It needs a little bit of explanation. In South Carolina, creditors may bring court action to recover debts only for a prescribed amount of time. Contracts generally, and this would probably include most retail installment contracts or credit card contracts, it's 3 years for unsecured transactions, 20 years for mortgages on real property. Judgments last 10 years. But what may be misleading is, let's say you finance a vehicle and you finance the vehicle for 5 years. What are you going to say? Okay, there's a 3-year statute of limitations, so after my 3rd year, I'm just going to stop paying. That's not going to work because that statute of limitations gets renewed each time you make a payment. The 3-year statute of limitations has to do with the amount of time that's gone by that you haven't made payments. So the clock can be restarted. And if the statute of limitations has in fact passed, that does not mean the debt is no longer owed. Creditors and debt collectors may still attempt to collect the debt, and they may still file the debt on credit reports until the Fair Credit Reporting Act will require them to take it off. Usually that's 7 years. Judgments will be 10 years. So what can I do? We can file a complaint with the Consumer Financial Protection Board, which we've mentioned in prior slides. You can file a complaint with the Department of Consumer Affairs. And there's our website where you can file complaints. We can get information from you and from your creditor to find out what should be properly done under the contract, what your rights and obligations are. You can consult with a private attorney. One of the ways to do that is at this website, https lrsscbar.org. That is the South Carolina Lawyer Referral Service. If you call that number, what you need to do, if it's a consumer matter, particularly if it's a consumer collection matter, is specify that to the answering person, and you will be put in touch, maybe not immediately, but you will be put in touch with an attorney who is knowledgeable in that area. Now, in some cases, you will get a limited interview with the attorney for no charge. In some cases, there is a nominal charge that you might need to pay. However, it's probably worth your while because in many situations, before you decide to attempt to resist or to even go to court to justify your actions, you need to have an attorney evaluate it to see if it's something that's worthwhile for you to do. What are your resources? Well, you have the Department of Consumer Affairs, and of course we've mentioned our website that you can contact us. You can click on Consumer Resources. You can get brochures sent to you either electronically or by mail, such as the Guide for Dealing with Debt Collection brochures. You're seeing a copy of it there on this slide. You can connect with us by Facebook, facebook.com/SCDCA, or in Twitter, now X, I suppose, @SCDCA. Likewise with YouTube at the youtube.com/scdca-TV. You want more information for free? All of our publications can be requested and sent to you completely free of charge, either electronically or by paper, including Ditch the Pitch, which is basically a way to avoid rip-offs and solicitations that are unwanted and quite often deceptive. The ID Theft Prevention Guide. It's always best to prevent ID theft than to get into a situation where your ID has been stolen and you have to unravel things. Credit Report Guide, and lots more. All these publications are available on our website, and all of these slides have our number and our web address. What are the upcoming webinars? Well, we only have a couple right now. We'll have additional ones from time to time. It's January 22nd when we will do a physical fitness and credit counseling frequently asked questions, primarily for industries that are involved in those. And another one that's more for consumers is January 29th for data privacy basics. Well, thank you, ladies and gentlemen. I enjoyed sharing this information with you, and I'm hopeful that you will contact the department if you get the opportunity for any of these or other consumer-related topics. Have a good day.